Hello, I'm Vince White. I'm an employment attorney, and we have a question from I think we're still going to call him friend of the channel because he is probably the most active viewer and commenter of the channel, and certainly I think this individual may have a future in employment law. I get the feeling we might be seeing the first stages of an employment attorney in the making. So here's the question. Although I am a huge fan of our court system and litigation as a primary means of dispute resolution, as am I, can you explain for the viewers the parameters of ADR? ADR meaning alternate dispute resolution, such as the cost of an arbitrator, time limitations on when adjudication shall be rendered, as well as the advantages and disadvantages of ADR, alternate dispute resolution. Okay, so let's take these one by one. And just for clarity's sake, I'll give a quick primer on ADR. ADR, alternate dispute resolution, comprises, generally speaking, two things: mediation, right? Parties getting to yes without someone making a decision, right? Without a judge, a jury, an arbitrator deciding who wins, who loses, right? It's an agreement, it's a settlement. Mediation is settlement that takes place over a short period of time, usually, right? Parties in the same room or on the same Zoom or virtual call, working with a third party neutral who helps facilitate discussions and negotiations. I certainly worked and was trained as a mediator. I mediated in a couple different court systems, and attended the mediation clinic during law school, and that's where I got my training under some great mediators, certainly. And I've had the luck to work with some tremendous mediators, the famous Martin Scheinman of Cornell fame, and I've had a lot of advantage in terms of working with people who really know what they're doing. Professor Bush, who taught mediation at Hofstra as well. These are people who know what they're doing in terms of getting people to a mutually unaccepted agreement, right? It's usually the sign of a good mediation when everybody leaves a little bit peeved, a little bit annoyed. It's a sign that you probably have a fair deal, right? One side's not giving up everything. The other facet, the other side of ADR would be arbitration, which is then having someone, an arbitrator, decide the case after a hearing. Well, an arbitration, it looks an awful lot like a hearing. And these are kind of the two different facets of ADR. Now, this question, I think, is aimed more at arbitration. Cost, because one of the first questions is, can you explain the cost of an arbitrator? So the cost of an arbitrator is set out in the arbitration agreement, which is forcing you into arbitration, right? So they're going to specify who pays what, who bears what costs, which arbitrators to use. Many use the American Arbitration Association. There are other associations out there as well, or you can hire a private arbitrator. And that's probably the responsibilities and the costs are, generally speaking, going to be set out either in the contract forcing arbitration or opting into arbitration, right? You don't have to be forced. You might choose to arbitrate of your own volition, or in the procedures and the fee schedules of the arbitration association that your agreement selected, right? And not every arbitration agreement selects an arbitrator or an arbitration association, but generally, I think if you're not specifically selecting the arbitrator or the arbitrators association in your arbitration agreement, that's some wiggle room that can cause trouble later. I don't love that. I don't think it's malpractice, but I don't know if it's best practice, right? So it's good to have some finality, some surety when it comes to knowing the future of your case. Time limitations, so schedules for arbitrations generally are going to be set out and promulgated by the Arbitration Association. Often these arbitration associations have strict deadlines because they want arbitration to be quicker and more efficient than litigation. That is, those are among the prime selling points of arbitration, right? You're getting theoretically a subject matter expert who can devote more time than a judge could and no more than a jury would, because juries are lay people, right, and who are not presumably experts in the field that they are sitting on a jury about. So often the Arbitration Association will set out time limitations in their procedures or their expectations for clients of ADR. Advantages. I think I did make a video about the advantages and disadvantages of arbitration. I will make another. I actually have a video series coming up that I've been working on because I work as an arbitrator for the American Arbitration Association. Certainly I've been through their training program, and you should not select me, because if you're getting this information from me, you should select someone you don't know. But you could, if you have an arbitration through AAA, they are, generally speaking, I think the largest arbitration association, especially in terms of employment agreements. I see them all the time, and I act as an arbitrator for them. So clearly, I think it's a good idea. Do I think it's a good idea for absolutely everyone? Sure don't. Do I think it's a great idea for some people? And I'm glad it exists. So I'm creating a video about when you might want to go the route of litigation versus the route of arbitration, versus get your case disposed of at mediation, versus file on dockets like the EEOC, the Equal Employment Opportunity Commission, or a state agency, right? And there's different considerations, right? There's advantages in the long run to your career if you keep things off of public dockets sometimes. There is advantages to your damages if you have your case decided by a jury sometimes. There can be, right? So there's a lot to think about there, and that, I think, is its own video. And here's the last question. It goes on. Additionally, if a court orders arbitration and a plaintiff violates the court order, the defendant can move to dismiss according to rules of civil procedure, correct? Well, so specifically, a court would only enforce arbitration and push a case, generally speaking, into arbitration if the parties had agreed upon an arbitration agreement, right? If they had a provision in some contract in which they both agreed to submit their disagreement to an arbitrator. So yes, if you are subject to an arbitration agreement and you believe it's fully enforceable, and that's a gray area, there's a lot of litigation that go on there, there's a lot of case law about some things maybe in some jurisdictions can't be forced into arbitration, but that's something where sometimes plaintiffs, there's a disagreement as to whether or not the arbitration provision is effective, and sometimes people will file their case in court, and the court might ultimately decide, after some motion practice, we do think this should go to arbitration, or no, we don't think this should go to arbitration. So to the extent the question asks, could the court make a ruling that a case should go to arbitration? Yes, a court could, where appropriate. I hope this helps. It's a great question. I look forward to your career, which I believe will be coming soon, of you as an employment attorney. I know that you've not told me you're going to law school or anything like that, but it seems like you are either going to be advocating for employment rights, employee rights, I should say, or maybe considering law school. So I'll be rooting for you either way. If this video helped you, consider liking and subscribing. It does help me to help more people. I will check the comments on the video. If you have questions, I'll try to answer them. I know that some of my answers were a little vague, and you may want to drill down on certain things here. And I'll try to provide more specificity where I can and where jurisdictional rules allow, right? I will not, generally speaking, respond in other avenues because the comment section for YouTube is really, really good in terms of giving me notifications so I can see your questions. I understand if you don't want to post them publicly. I totally get it. But if you have a question that you can make general enough that it can be posted publicly, that is the best way to do follow-up on these videos. Good luck to all of you.